We've got Mr. Kunle Edun here with us. He's the Publicity Secretary of the Nigerian Bar Association. Thank you for coming on this morning.
Thank you. Good morning.
Well, from the look of things, this seems to be going on, at least in one way or the other. I know that there are different prayers before the CCT and some of the courts, but concerning this warrant, I mean, they've been explaining why that was the case, because it's been the fourth time, and then he's not appeared. So in that context, are they in order to have issued it?
It's unfortunate that Nigeria has come to this mockerist level of purported dispensation of justice. The CCT was wrong, held, and what the CCT actually did was to further debase the institution of justice in this country. There's no way you can say you are dispensing justice without adhering to the process of due process and rule of law. For about 7 or 8 reasons, the order that the CCT chairman made cannot stand. And by the way, we recall that the president of the Nigerian Bar Association has issued several statements. I think the latest one was about the 4th statement, which was issued about 4 yesterday, still condemning the processes, the procedures adopted by the CCT, and also urging the executive arm of the federal government to withdraw the charge against the Chief Justice of Nigeria, Honorable Mr. Justice Walter Onnoghen. For the following reasons, that order that the Chief Justice be arrested cannot stand. These are the reasons. Number one, there is already, on the basis of the same set of facts, a petition, I think about 2 petitions now, before the NJC. One was submitted by the EFCC, and the NJC is sitting on the same matter. The NJC, good enough, has been treating these matters in an accelerated manner, which is very, very unusual, but knowing very well that the nation and the international community, they are all interested, and they are giving it accelerated treatment. Another ground is there is also this matter pending at the Court of Appeal.
Which of them?
The Court of Appeal at Abuja. Because Mr. Dalande Umar, I will call him a Mr. Dalande Umar with due respect to his person, because he's not a judicial officer. He has already said that he reports to the presidency. So, since this is not under the judiciary.
So if in that respect, why was it necessary for him to be issued a query if he's not a judicial officer?
The Federal Judicial Service Commission is under the executive arm of the federal government. So it can rightly be issued a query by the Federal Judicial Service Commission, because that is under the executive arm of the federal government. So like I was saying, the further reasons why that order, the purported order, cannot stand, there's a pending appeal in respect of the order he made with respect to the same case.
But you know that, sorry to butt in that, but you know that there was also an order which did, Justice Onnoghen tried to get a stay of execution in terms of them proceeding with his case at the CCT, which he lost the case, and decided the ACJA saying you can't in criminal matters.
Lost at the Court of Appeal.
Yes.
Yes.
So if they rely on that and continue with the proceedings, are they out of order?
The CCT is also out of order, because why? There's an appeal pending. Once an appeal is pending in respect of a particular matter, it's always advisable for the trial, I wouldn't say, it's not a trial court, for the tribunal to stay proceedings. It is better that way. That means you are showing respect to the Court of Appeal.
So what kind of effect will that decision have in the proceedings, where they say, no, under the ACJA, you can't actually stay proceedings in criminal procedure?
At the end of the day, if the Court of Appeal decides in favor of Honorable Mr. Justice Walter Onnoghen, the substantive Chief Justice of Nigeria, what it means that everything that Mr. Dalande Umar has done is a nullity. Waste of precious time, waste of taxpayers' funds.
Is it about him, or is it about the CCT?
It's
because you say that the CCT has aired, and basically, I'm wondering, as other people will be at this time, does it have the jurisdiction in the first place?
Considering the facts of this case, I don't think the CCT has jurisdiction, because The statement of Honorable Mr. Justice, or what Onnoghen was that he forgot some of these accounts and he did not record them in his asset declaration form. So on the basis of that, you don't need to charge him. The law is so clear on that. It's so settled. You don't need, it's not necessary. A law school student knows that. So you ask a question, whether if it is because of the person of Honorable Mr. Dalande Umar. I think Nigerians have come to say that there are certain things that are playing out here. By the way, there's already a motion pending before the CCT urging the chairman to recuse himself because the Chief Justice of Nigeria no longer has confidence in him. That motion is still pending. It has not been taken. As a matter of fact, 2 motions are pending, one on substantive jurisdiction of the CCT and this one. So the matter, as at the penultimate time, was adjourned for these motions to be taken, not for the substantive trial. So what basis would you not issue a bench warrant? We should be very careful. We should not mock the judicial system of this country because investors are watching us. International community, watching. They've all condemned this process.
Would you consider the absence of Walter Onnoghen, the CJN? Difficult to know how
No,
to...
he's the substantive Chief Justice of Nigeria.
Okay. Would you consider his absence in court as a problem? Because that may just form the basis for seeking his arrest.
His access in court is allowed by the law. Why? Because the matter, the CCT proceeding was adjourned for interlocutory applications to be taken, not for the substantive hearing. Once I put of the ACJR, that's the Administration of Criminal Justice Act, when interlocutory applications have been taken, the necessity for the defender to be in court is of no moment. It's of no moment.
So if they know that, do they then think that this interlocutory application is a precursor to the trial process? Because they say for him to, he needs to be there to take his plea.
It does not, look, this is common sense. In being there, plea will not be taken because the jurisdiction of the CCT is being challenged.
How do you balance common sense with perception then? Because the perception is that he doesn't want to appear in court.
The perception out there is that CCT is playing funny. That's just the truth. All the processes, or whatever they have done, they are certainly not in line with rule of law. Certainly not.
Does that negate the substantive issue, which is the infraction committed by the CJN?
And the CJN has not denied it. What is actually expected is that, having not denied it, okay, you've not denied, okay, now can you do the right thing?
So why was that
Simple.
never brought up when when he was being represented before the CCT?
It was brought up. It was brought up as part of his response, as part of the applications that were filed. He never denied it. And let me tell you the good reason why the lawmakers made that provision that if a public officer doesn't deny allegations with respect to his asset and liability declarations, one, so that you do not waste taxpayers' funds in unnecessary prosecution. Two, okay, you forgot, okay, the facts that you forgot, okay, let us have the full facts, full disclosures. Now do the proper thing.
Has he done the proper thing?
The question now is that, have they given him the opportunity?
Does he need an opportunity to do the proper thing?
He doesn't need the opportunity to do the proper thing, you are saying so, because he will still need to file further assets declaration forms to reflect this, to reflect the properties that he did not declare. The question now is that the opportunities have not been given to him. Rather, he's being persecuted every now and then. By the way, you recall very well.
I find it interesting that you use the word persecution here because there's a question that I've asked over and over again, and I'm still not persuaded with all the answers I've gotten so far. The CGN is a judicial officer, correct?
Certainly.
The CCB is set up for which caliber of people? Public officers, right?
Officers.
The CGN is also a public officer, correct? Okay. The infraction is under which law? The CCB Act or an NJC infraction? Which of them?
The question, to answer your question, whatever act of omission or commission that was done by the CGN was done in why he still remains a judicial officer.
But let's not mix issues.
And in that wise...
So, excuse me. You are first of all, a Nigerian, then you are a lawyer, right? So if you commit an offense as a Nigerian, are you judged as a lawyer? I don't think so. So let's draw the line.
It doesn't
first.
apply here. We're talking about judicial officer. As a lawyer, certainly I will not go this route. I will go the route that ordinary Nigerians go through. But in respect of a judicial officer, let me tell you the good reason why the judicial officer must first be taken before the National Judicial Council. This is the reason. The National Judicial Council will look at it, look at the facts, and if they find it liable, they will sanction him, and thereafter hand it over to the appropriate authorities. Let me tell you another good fact. You do not arrest
before you move off
an army officer and charge him to court. He must be disciplined by the appropriate authority. That's the military authority.
How can justice seem to be served? Because he's the boss of the
entire
NJC.
He's the head of the judiciary, and that is why NJC has to play its role, which it is actually doing. By the way, were it not for the pressure that the Nigerian Bar Association and all lawyers in Nigeria put on the executive and the federal government, they wouldn't have sent a petition to the NJC. But good enough, we thank the federal government for doing the needful. And having done the needful, the NJC is treating this matter expeditiously, which they should have done since. I think they had actually done it. We wouldn't be seeing all this.